As a former mayor and as a councillor since 1999 and then standing down in 2011 upon my election, I have had a very deep experience in my own local community. I've found the vast majority of councillors to be very decent people, to be people that are genuinely committed to their community, to be doing work for a very small amount of money because they love where they live and they want to make sure that their community can be a better place. And that's something which I wanted to acknowledge at the outset. This bill, of course, seeks to create a scheme for dealing with misconduct, for councillor misconduct, as well as making changes to the process around the plan making under section 451 of the Act, meaning that councillors cannot vote on planning decisions that they have a pecuniary interest in unless that interest is in their primary residence. And there's a very positive step forward in this bill. We won't be opposing it. We recognise there may well be opportunity to enhance provisions in this bill, but as it stands, the bill is making some positive step forwards. Mr Deputy Temporary Speaker, we've seen and heard all of the details about this legislation. I wanted to highlight just a few of those points. The bill institutes a scheme whereby 3 suspensions from civic office by the Chief Executive of the Department of Local Government, or NCAT, can result in disqualification for 5 years from holding civil office. Now, suspensions before the Act commences count towards the 3, but the final suspension must be after the Act commences. And I note that the Legislation Review Committee identified the retrospective nature, the potential retrospective nature of this legislation, yet this provision about ensuring that the final suspension must be after the Act commences is a positive act which militates against that sense of retrospectivity. The bill also reduces time for councils to respond to reports from the Department of Local Government following investigations from 40 days to 28 days, reports from the Director General from 40 days to 28 days, and makes the same reduction in time for the Minister to require the Council to do things recommended in the report. The bill creates a power for the Minister to vary a performance improvement order. The same notice requirements apply to this as making an order, and the Minister must be advised in terms of the proposed variation and the reason for change. And it further reduces the time period for notice giving a performance order from 21 to 7 days where the notice is served. Currently 7 days is the period required only in the case of urgent periods. Mr Temporary Speaker, we Greens have some significant concerns about some areas of the legislation which are shared throughout a great deal of the local government sector. When it comes to the first matter of councillor conduct, there's a real political complexity, of course, around one level of government, one sphere of government, state government, legislating for the workplace conditions and disciplinary mechanisms for other elected representatives. In general, the tendency of this coalition government over the last few years has not been about returning planning powers back to the community, but has been increasing the power over local government, shifting costs onto local council and removing planning powers. In this context, it's understandable that many local councils have concerns about the Minister's intentions with this bill and with the prospect of forced amalgamations hanging over their heads. We acknowledge, however, that there is some need to improve the process when councils are failing to appropriately discharge their duties. However, such changes, such as reducing the time for consultation on a performance improvement order from 21 days to 7 days in all cases, without any kind of requirement to prove urgency, in our view, it will diminish the quality of decision-making and is a decision which we think should not be supported by this House. The removal of appeal rights on minor matters is also a point of concern. While this is limited to disciplinary action in the form of counselling or a reprimand which are private and not enforceable, nonetheless, the reduction or the removal of this procedural fairness in terms of allowing those people to have an appeal right, we think is a critical element. We should be allowed to have some form of procedural fairness, and we do not support this element. When it comes to councillor pecuniary interest, we need to amend section 451, and of course that's the provision that allows councillors to vote to rezone their own properties, and it's something that I've spoken out strong and loud about since the laws were passed in April 2012 before the local government elections in September. It's now October 2015, and many local communities across New South Wales have seen the planning decisions compromised by councillors with vested interests when it comes to the voting on new LEPs and rezonings. The legislation, scandalous in fact, the legislation allowed councillors to vote on rezoning proposals, changes to development control plans and other broad planning decisions that impact on land they own, opening the door to wide-scale and legal corruption at a local level. And I'll give you some examples what this legislation allowed. It allows councillors who own shops in commercial precincts or other land holdings to increase the floor space ratio on their land and thereby greatly increase the development potential and subsequent value of their properties. In many rural and regional councils, particularly in growing areas such as Dubbo, Orange, Albury and Wagga Wagga and the like, these are growing areas, there were votes to rezone land that councillors own on the outskirts of land from rural to industrial or to residential, thereby reaping potentially very, very large personal benefits. Councillors should not be able to vote on those matters. They'd see their land, which might be zoned industrial or rural, to be zoned residential. Huge uplift in their values. In our view, that is something which is a direct conflict of interest, and it was a terrible decision that this government changed the rules to allow councillors to be able to vote on these issues. We've also seen councillors who own commercial or industrial land to vote, for example, to water down contribution requirements, to councillors' council-wide parking development control plans when there's a change of use. So, for example, changing from low off-street parking use of industrial to a higher commercial, thereby they deliver themselves hundreds of thousands of dollars in benefits, hundreds of thousands of dollars in savings, that if they change from a less to a more intensive use. It also will encourage property owners and property developers to put up their hand to run for council. It encouraged them to put their hand up because they thought, hang on, I can vote on rezonings now. I'm going to run for council. The legislation was introduced before the council elections in September, and they, of course, then had the opportunity to vote to improve the development yield on their land and personally enrich themselves. In other words, it was a golden invitation to carpetbaggers and developers to run for council because they were legally allowed to vote on matters which the normal person in the street, I'm sure will agree, would recognise as being a conflict of interest. So, to this end, we'll be moving an amendment in the other House, and we'll be hopefully encouraging all parties to support it. Amendments 1 to 3 that make the amendments to Section 451 to commence on the day of the assent of the bill, and that requires the Office of Local Government to undertake an audit and report to the Parliament within 6 months, an audit of all planning decisions made by local councils since the 2012 amendments of the Act, where a relevant declaration was made by a councillor, where Section 451 declaration was made by a councillor who then voted on the planning matter. It's our view this is a small way to understand the impact of this legislation, which was made back in 2012. The audit can consider if the public interest has been or may have been compromised, or if there is a reasonable apprehension the public interest has been or may have been compromised by the council's conflict of interest. Now, we're limiting the audit to circumstances where the pecuniary interest arises in areas that's other than where the only interest of the councillor is in the councillor's principal place of residence or an interest of another person whose interests are relevant under Section 443 in that person's principal place of residence. We're also seeking to keep the current 40-day response time. We think councils need that. 40 days is not an unreasonable period of time, rather than the reduction being proposed. As I've mentioned previously, we believe that Schedule 112, where a 7-day consultation period replacing a 21-day consultation period, is not allowing good quality decision making, and also we'll be proposing to delete the provisions that allow surpass suspensions to be relied upon. So, Mr Assistant Speaker, we know that the vast majority of councils, in fact it's remarkable, the amount of councillors which are selfless, contributing to their community. In areas of poor performance and councillor misconduct, we do need to have strong provisions. But whether it's about introducing caps to local government elections, whether it's not providing an invitation to property developers to enrich themselves, the government can and should do more. The government should immediately move to implementing the Electoral Funding and Disclosures Act to be including local government, so caps on donations to local councils, which apply to us as state MPs, should be applied to local councils. Because in so many areas we see the money flow into local government campaigns